Welcome back. Now, we were following closely the Deputy President impeachment hearings in court today, and so far the update is that particular hearing has come to a halt by now, but we're expecting the ruling on Thursday. I'm advantaged to have very key, brilliant panelists in studio today. Kidi Mwaga, who is a lawyer and convener Inter-Parties Youth Forum. I'm also here with Odoyo Widi, who is a political analyst. We're very honored also to have Duncan Okach in studio, who is a lawyer, but also sometimes it gets a bit confusing. Allow me to also put it out there. You'll correct me, you're an advocate of the High Court of Kenya. Now, different submissions came in play today. Perhaps it's also good to bring in that analysis. There was a concern about certain narratives that are coming up, including this one, Wakili, that the National Assembly, Senate, and Executive have a dictatorship and an autocracy on political questions that can't be questioned by the courts. Where was this driven from, or what is your observation on such submissions seen earlier today?
Yes, I think this is one of the major groundbreaking, or what I've called unprecedented decision that we expect once the court gives us or renders its ruling on this matter. Ideally, when you look at these particular proceedings today, they were merely meant to deal with the application as to whether the orders that are there should remain in place or should be discharged or vacated. So it was supposed to be simply that.
Perhaps if you want to not lose us too far, the orders that are in place, the last we checked, there was over 30 petitions consolidated into, quite a number, or two main orders were in the courts. And as far as, our following is concerned, so when you're talking about these two main orders that you're referring to, which ones, to be specific, are you referring to?
There are two orders that were issued by two different courts.
Yes.
One was issued by Justice Chacha Mwita, and another one soon thereafter by Justice Mwongo, that is in Kerugoya, around there. And the orders, the essence of the orders, they are conservatory orders, essentially preserving the status of the Deputy President. And the Justice Mwongo's orders went even further as to stopping the swearing in of Professor Kindiki. So those orders were in place. So what happened is that the government, that is the Attorney General, actually filed an application to say that, wait a minute, before we even deal with this case, we want to deal with the question of whether these orders should continue to be there or not. Because orders are normally issued pending the hearing and termination of the main case. Here it's called a petition. But in between, if you feel these orders were, there is proper reason as to why these orders ought not to remain in place, you can move the court, you can apply. So what we were dealing with today are those applications, and the only decision that this court is supposed to make is, will these orders remain or will we discharge them, even as we move into the stage of proper hearing of the claims by the Deputy President and the other petitioners. So ideally, we didn't expect, so many arguments to the extent that someone will think or assume we are arguing the main case. If you sat today through these hearings, actually we were like arguing the entire petition, which I think is wrong, and I had the court trying to redirect parties and parties redirecting themselves. But it was, in my view, wrong and not a proper calculated move to actually file that application at this point, because you could have as well said, let's hear the petition today. By today, they will have finished hearing the petition. If the court has given a date on Thursday or tomorrow or Friday, that will have been a date where a judgment will have been issued. That judgment will have finished this entire matter, and that issue of time will not be an issue. However, in the wisdom of those who decided to file, they actually filed this application. Of course, there are two options. If, assuming that the court declines to vacate those orders, this time will have been wasted.
All right.
But if the court agrees with them, then it will be very good, because it means they can move. But remember, if the court, any of these parties can disagree with this court and quickly move to the Court of Appeal and still get orders until that issue is heard. Remember, we are still dealing with an application, not the main matter.
All right, so I'll come back to you. Allow me to hear from Odoyo Widi as well, because there is that concern, and you've heard what Wakilia said. We don't want to come to a point where we will declare that the court wasted our time when we're looking at a very critical position of the second in command. How do you view this in your own political analysis lens?
From where I sit, from the political desk,
yes,
I think what is happening here is people are trying to use the courts to gag the legislature. For example, I think there are times when when petitions go before courts. Take, for example, electoral petitions. The person has a case, but the court must also consider, suppose we grant him his prayers, would he now win this election? Suppose we grant the DP his prayers, and probably even the court directs that you are not properly treated at the Senate, go back. Does he have a chance?
When you said the DP, who are you referring to? A deputy president, the impeached deputy president, the nominee, the former? Okay, okay.
The former. So I think also the courts must also be aware that it is possible that we leave this place with certain jurisprudence that will affect future cases that may not be good for this country. Also, if they also make very drastic rejections of the prayers of the former DP, it may also be a mistreatment for people who would, in future, seek the court's intervention in what happens at the legislature, both the Senate and the National Assembly. But I believe the people serving the interest of the former DP are trying to use the courts partly to gag the legislature and also to delay. Whatever their reason for delaying, I don't understand. But if you look at it from a political angle, that decision that was made by the Senate, they made it knowing very well what probably would the then DP would come and say in that assembly of the senators. And I'm sure even if he was to go back there, given an opportunity to be heard, and the opportunity to be heard would mean he was going to be cross-examined, go through the heat that Mutuse went through. I can tell you his would be worse, because before they went through the cross-examination, it even looked like that Mutuse had an upper hand. But when Mutuse went through the baptism by fire, I think we sat back and said, really? If the then DP would go through what Mutuse went through, probably the Senate would have voted against him with many more votes than it happened.
But although even as you're speaking,
yes,
the legal team representing the former deputy president,
yes,
impeached deputy president, is making it very clear that he was not moving away from that, moment of cross-examination or clarification. In fact, he was reported ill. And in fact, what they're bringing up right now is the right to fair trial, that he needed to be heard at that point to go through what you're saying Mutuse was going through in your own description, baptism through fire.
Let me tell you, you use your observation and precedents to judge what to expect.
All right.
I said here that before the Mutuse even went to be cross-examined, he looked like he had an upper hand to the person who was accusing, who was the DP. But when he went through the cross-examination, he looked weak. His case looked weaker. Now it was now time for the DP himself now to go through that baptism by fire. What happens? He suddenly fell ill. Falling ill can also be psychological. It doesn't have to be physical or something to do with health. No. In fact, from where I sit, when I saw him come from the hospital, I started wondering if he was really sick. When people get out of hospital, there's certain changes in their physique and appearance, even the body color. It did happen. So I suspect he was running away from cross-examination. Nevertheless, even if you are not running, I can tell you, the Senate, if you were to go back there, it would be worse off. He knows it, and that is why he's playing these games we are seeing here.
Playing these games. And I remember on Friday last week, the two-judge bench was very clear before they took that weekend break, and they told each parties to file their responses and serve. And if I just quote the judge, Justice Ogola, he said, "Do not take the court in circles." We have seen that recusal, verdict challenged by the deputy president's team as well. I'm bringing Kidi to this question. Do you agree then with our political analyst in studio, Odoyo Widi, that there is some sort of intentional delay that is being seen at this point in time? Because even as we're waiting for the ruling on Thursday, we have that appeal on the recusal, verdict.
I think there is a deliberate attempt by the defense team of the deputy president to use the court process to drag this matter out as long as they can. And I think from a political standpoint, it is indefensible. It is indefensible because while the deputy president has got, the impeached deputy president has got the right to say fair hearing and all these other things, there is a country that needs to move forward. There is the national interest that is at stake. There is this whole circus that the entire country is dragged into, that I think the impeached deputy president in good faith should have been in a position to save the country from by moving away from all this. So for instance, there was the two petitions, both in Kerugoya and elsewhere, that was the conservatory orders. One, stopping the swearing in of the new deputy president. Of the deputy president designate or nominee? Yes. Okay. I'm guided. But then the question is then, yes, you see, conservatory orders are supposed to preserve a salvageable situation. So as at this point, did we have a salvageable situation? The Senate, in its wisdom, had moved ahead and passed a vote on the unsuitability of the deputy president impeached, Rigathi Gachagua. So then we didn't have a deputy president. A Gazette notice had issued that there was a vacancy in that office. So then the question is, and I invite our viewers to help us reflect on this. Right. Did we have a salvageable situation as at that point in time? In my view, I could be wrong. I think that as at that point in time, Rigathi Gachagua stood impeached. And in the interest of the country, because we have also seen that they didn't have a working combination with the president, that he had, in the course of his tour of duty, antagonized so many people, antagonized so many institutions for all it was worth, in the interest of the country, so the country is able to focus on that which is important. He should have stepped back and let the country move forward. Thank you. Very interesting. Let me hear from Wakili Okash, because Wakili, Kidi here has mentioned the Gazette notices, and I was following the submissions today, including from the 12th petitioner, and I believe that is Kidi Mwaga. She even brought in some certain files. I think that was file E65 of 2024. One of the things that was thrown in is this Gazette notices, according to some petitioners, were put out wee hours of the night. Does that concern as well on the jurisprudence and jurisdiction, perhaps even as you respond? And if I quote the 12th petitioner, she said that the courts don't have the jurisdiction to force Kindiki to impeach himself if he's sworn in, based on if they would vacate some of these conservatory orders.
Yes, I think that still leads to the first question that you asked me, which I had not answered. There is already this question that is called the political question doctrine, which allies to what Mr. Widi is kind of saying. People are saying that decisions by, constitutional bodies like the legislature should not be questioned in court. And specifically the impeachment aspect, which is very clear. That at the point where the Senate pronounces itself, if it is the deputy president or the governor, you stand impeached. However, personally, I believe that is a fallacy. It is not proper, because the same constitution says that anything that is done under the power or the strength of the constitution can be looked at, interrogated by the court. So if we are to allow, and I'm happy that Owidi is very, very at least balanced. He also says that, if you allow some transgressions to happen by either the legislature or any other entity, and you say that the courts cannot look into it, then it negates the very essence of protecting fundamental human rights in the Constitution, but also negates that very aspect, the center of protecting rights. So it cannot then be said, in my view, and the courts will have their own view on that,
All right.
that you can say that the court cannot intervene. So when someone then argues at this point, and in terms of the petitioner you've talked about, of course, the essence here is that even at this point, the court is not going to say whether the impeachment, and that's what the court is trying to reframe,
All right.
whether the impeachment process was correct or not at this stage. All they want to say is convince us whether it is it is better to discharge the orders or to maintain the orders. But that, and many Kenyans will try to confuse that with the fact that if they maintain the orders, it means they are already inclined towards accepting that the impeachment process was wrong. Or if they decide that they are going to vacate the orders, they are already inclined towards saying the impeachment process was correct. Not at all.
All right.
Whatever decision comes, it does not imply or give you a certain indication of the court's thinking, because the case has not been heard. But as I say so, remember that as we are proceeding, there's that notion of saying the former president. Let me tell you, the courts have given, the former deputy president, the courts have given their orders. Those are conservatory orders. And it is very clear, as far as the courts are concerned, the deputy president of this republic is Rigathi Gachagua. After their decision, then another deputy president can take place, like the Professor Kithure Kindiki, who is the deputy president designate. But it depends, at this particular point that we are speaking, the orders are there, and that is why they are arguing in court. And that is why it will be very wrong for you to be convinced to refer to him as the former deputy president. You can say the impeached deputy president. That's accurate.
Okay.
But as to the former, you must then wait for this court to render itself, then we will move forward.
Let me invoke Article 27, just for clarity. I'm coming back to you, Kidi. And this is what a petitioner brought out. She actually said that it seemingly is a trial on the Constitution. Is the Constitution on trial? In fact, also asking then if if jurisprudence will prevail. I just need some sort of clarity on that. When a petitioner questioned if jurisprudence would prevail, what exactly do you think they were pointing at?
What they are trying to say, and they are very right.
Okay.
You know, constitutions, I've told people, constitutions grow by the manner of testing, how many times you've tested it. Each article of that constitution, if you look at the American Constitution, it has been tested so many times. And anytime you test an article, it grows, it matures. So this article 145, Article 150, has never been tested before. So the moment we test it, we create jurisprudence, and in future, there'll never be a question about these issues. So it is a good process, it's a good question, and it is something that we should laud ourselves, that we can actually take such a dispute to court. And that is why I still say it is proper to say that such disputes can be looked into by courts, and the court will render itself. That is the civilized way of dealing with things. But you cannot have senators coming and members of parliament coming to tell you that whatever they will do, you cannot question. And look at how they think. Kenyans question their decision when they actually passed the finance bill and it became an act. Kenyans told them no, but they pretended they didn't hear. Later on, the president actually, through his statements and actions, they have revoked that particular bill. Or that particular act at that point. But that tells you, you cannot then trust Senate and give it absolute power. No entity can be given absolute power. Not even the president. Even those gazette notices.
All right.
How many times have gazette notices been declared null and void by the courts? How many times have the courts declared presidential decisions as unconstitutional? The courts have that power.
All right.
And the day we decide that we want to remove that power, it is Kenyans through a referendum that will decide, and that will be anarchy by itself.
Interesting, he's used very strong words, including anarchy. Let me hear from Odoyo Widi, because even as we're speaking, the UDA party is, on toes, making sure that they quickly replace Rigathi Gachagua with Professor Kithure Kindiki in the position he held or holds. It's very confusing at this point in time. But you've heard what Wakili is saying. The excitement on the court declarations on these two orders might not be what everyone else seems to think.
First of all, I have seen the courts, especially from the defense, it's so full of moral arguments. There are no legal arguments there.
Is it?
Moral arguments. Why was this thing?
Not even with the articles being evoked?
Wait a minute.
All right.
Listen to the case of somebody coming to court to tell us that why was it gazetted at night. There are no times in law anywhere where things are supposed to be gazetted. And two, remember, even the gazettement of, say, myself, I went to sleep without a gazette notice. I woke up with one. When was I gazetted? Because, when is a gazette notice said to be done? When you see it or when it is printed? So the time when the gazette notice appears is neither here nor there. Right. So those are moral arguments. So those are the public gallery arguments. We also need to look at Article 145 about the power of the Senate to impeach. That article says that you stand impeached as soon as the Senate pronounces itself. So I don't know whether you're supposed to wait a few minutes to see if the impeached is going to run to court to come and challenge this. And when that does happen, are they going to reappoint you because you stand impeached by the action of the Senate at that point in time? Leaving that, also, if we want to go to moral arguments and political arguments, one of the reasons why we must have a DP is the risk of having no president in case the president has issues with his health or with his availability. So what are we doing now? We're standing a very big risk.
Ask Owidi, who is the governor of Meru,
so
and if she was also impeached through a gazette notice.
We'll go there. We'll go there. So
it's important because we've seen those comparisons.
This very impeached DP has accused his boss of trying to assassinate him from his statements of what happened in Kisumu. He has publicly insubordinated this very boss, but he still insists, he still wants to remain his principal assistant. Don't you see trouble there? You want to remain my boss, you want to, my deputy, you want to walk near me, you want to assist me, but you believe I am a potential murderer. You believe I'm a potential assassin. Also, this is the same person who wants to decide which judge listens to his case and what results to come out of it. I think he's going to lose a lot of public support. That is going to happen from a political angle.
All right, let me hear from Kidi. I saw Okash wanted to respond to because we've had those. We do not have a proper legislation, really, around impeaching a deputy president. And I know that Wakili also said that, but this would set precedent. Yes. But you've heard what Odoyo has said, Odoyo Widi. I don't know what you think, though, Kidi, to this point in time, because there was a concern on the immunity of the office of the, the president being on trial, of the deputy president, immunity, to underline that. And what you have said, there was a raised question on moral question that was also raised, and I'm glad Odoyo brought the moral conversation. Yes. So, and as far as the conversation is going as well, where do you stand, Kidi, in your observations?
I still hold the view that when we raise the questions of morality of the entire process, then it is also incumbent upon the deputy president impeached, Honorable Gachagua, that he is in a position, an untenable political position. He clearly has got a boss that has demonstrated that he is unwilling or unable to work with him. He has got both the National Assembly and the Senate that has pronounced itself that he is unfit to hold office. Then therefore, this is what has brought us to the courts, to the High Court. I have a proper understanding that right to fair hearing is non-derogable under the Constitution. But then some of these questions are beyond the legality, particularly where the interest of the nation is at hand. While the deputy president has got even the right to have this matter or all these petitions had consolidated to the court of last resort, being the Supreme Court, then from where I'm sitting, I'm asking myself, then where is his regard for the country? And the regard for the country here is that the country should be in a position to move forward, so that even as he was testing the fairness of this process, he could have these processes tested as to the legality or lack of it when he is willing, from a standpoint of good faith, to step aside and let the country move forward. There is the example that everyone cites when it is politically convenient.
All right.
The case of Jaramogi Oginga Odinga in 1966, when he says that he has realized, he has come to the sad realization that he holds a sinecure position. Sinecure is an English word meaning it is a big title where you earn salary, but you have got very little functions. Jaramogi was ahead to say that because I cannot, in good faith, with a clear conscience, keep earning a salary in a country where there are so many poor people, I take this opportunity to step aside. I think that the deputy president had an opportunity to rise above this fray by moving away from this earlier on, before he was impeached. Right now, because he has been impeached, there is the legal implication of that impeachment. And then now that he's here, is he willing to step back in the interest of the country and say that I am not going to contest as to be a deputy president or not? Thank you, that's my thinking.
You know, there are certain things that when we are told in these matters, I say we are not very, very honest with ourselves. Because the essence of conservatory orders did not start with this impeachment.
All right.
Wambora was impeached throughout his entire lifetime as governor, the 2 lifetimes. And he remained in office when his matter was being had and when there were conservatory orders. It is not the first one. Peter Munya was also impeached. It is normal. It's not something so new that we can say it is so new that the court needs now to relitigate and reinvent the wheel. But when we look at Kawera Mwangaza, she was impeached. The same Gazette notice was issued, the same process, because it's a mirror image. And at the end of it, save for the fact that, of course, it is a mirror image, save for the fact that it doesn't go through the 2 tiers process. But nonetheless, once that happened, the courts gave conservatory orders.
All right.
Kawera Mwangaza is receiving money from the exchequer today. Kawera Mwangaza is dealing with that county, and no one has appealed. Remember, there was a decision, and no one has even gone, not even the AG has tried to go to Court of Appeal or the Supreme Court to get an interpretation on that. So we must, one of the fundamental doctrines in our constitution is let's treat everyone fairly. You may not like Gachagua. Personally, I don't even like a lot of what he said. I do not even agree. But one thing I hold true is that fairness has no color, has no language. An unfairness in one part of the earth is an unfairness to you because it goes around, and we were talking with the Weedy. We said it can come back and catch up with your children. Now, on the other aspect, you are being told the issue of vacancy. What if vacancy occurs? I don't know. This vacancy, if it occurs, there is no issue because there is already a deputy president who was elected with the same number of votes with this other person. So if a vacancy occurs today, let me tell you, the decision by this court is going to address that issue. Either it is the current deputy president or it will give way to the deputy president elect or designate based on the court's decision. And we believe this court, in appreciating that agency, is going to render itself, I believe, I was not following, but I'm sure a date is already given. The other issue you've been told is that, oh, if he goes back, they are fallen out in subordination. You know, we must talk like people who are born, who are not born within the last 3 or 2 years. Because remember the last year of Uhuru Kenyatta's reign. Were they bosom buddies with William Ruto, the current president?
But there was not an attempt to impeach the then deputy
It doesn't
president.
matter. There was no love lost. It's not about the impeachment. The issue is you are being told they are not in good terms, so they cannot, you know. And the question is, we've had experience of 5 good years, people not being in good terms.
All right.
And the country did not grind to a halt. If someone, you know, the deputy president has no role. This is a person who just can sit in Karen and earn his living, and the country will not grind to a halt because he has no check that he signs for this country. He has no handbrake that he has for this country. Remember, it is like deputy governors. You know, if I ask you who is the deputy governor of Kwale, Who is the deputy governor of Mombasa? Who is the deputy governor of Moranga? You will not know, but they are there. So that essence of saying that a deputy president, the country is stopping because there's this impasse of a deputy president is actually a fallacy. And I don't think such a reason can be compellable enough to negate what Kidi has agreed. Article 25 is very clear. Right to fair hearing.
All right.
Mgema muwe lakini haki yake umpe. Give him his right. He's so bad. If you have all these things against him, why are you afraid of going through the process, finishing properly? But if we set a bad example, let me tell you,
yes.
And I have to say this, let me tell you, we don't defend these matters or look at the rule of law because of an individual. Yesterday it was William Ruto was out, and I was defending him and many people affiliated to him. Today he's in power, and many people who are in power are out, are the ones suffering.
Okay.
We defend the rule of law because it doesn't matter, it should not matter who is there. The law must apply straight, even if it is the devil. In fact, we always say if Lucifer comes here, you'll be so shocked how many lawyers will line up to say, we know he's bad, but take him through the due process.
It's very interesting if you're also bringing in names like Lucifer as comparisons. But let me bring this. Elisha Ongoya, in his submission, said, even the National Assembly did not even pretend, and I'm reading this directly, to have an iota of public participation, something that we discussed before we took a breather. No Kenyan, according to Elisha, was given a chance to express their views on whether Professor Kithure Kindiki is suitable to be deputy president. Now, gentlemen, you've heard these concerns about IEBC, who cleared Kithure Kindiki, and now Elisha brought this in today saying, who in the public participation even said that they are okaying Kithure Kindiki as the deputy president designate or nominee. I don't know what you would say, Odoyo, at this
First
point
of all,
in time.
first of all, when you are pointing Rigiji, where was public participation?
All right.
When you are appointing the cabinet, where was public participation? I think we are taking the joke of public participation too far. But I want to plug in a few holes that I think Wakili left out. Wakili had brought in the case of Bambora and said it lasted forever. And I think that was not a good thing. It is the mischief now we must use the courts now to cure. Such mischiefs will come that impeachments will be rendered useless in this country. So, and these impeachments are political process done by the legislature. So I think this is what the courts must now put its foot down to come and cure. And the Wambora case, nobody seemed to have realized it because the risk was much lower. Here we are dealing with the whole nation.
The risk was much lower.
The risk was much lower.
Okay.
It was just a county.
Oh.
Yeah, but now we are dealing with the nation of Kenya, where we are having this. But for me, it is not something we should copy. It is not something we should cite in the future because it was a bad thing. For somebody to impeach, then he uses the court process negatively to stay in power for almost 3 years. Then I've heard many people talk about election of the DP. There is no election of the DP, not in Kenya, not in the US, not anywhere. What happens is we elect the president, but the constitution demands that the president nominates his DP before the elections. So people are electing him knowing who will be his DP. There is nowhere where you vote for the DP. The DP information that appears on the ballot is additional information like a nickname.
Is it?
Yes. No. So let us not treat the election like we are electing a DP. We elect the president. But the president, according to the law, must tell us in advance who will be his DP. Let me just finish with something.
All right,
this is the question I want to ask. What is the best that the impeached DP expects to achieve after the court process is over? Go back to the Senate for another vote or to be heard? And what does he expect to achieve after that? So the courts also need to look at the way I began, that you can have a petition, and the petition, we go to court. Kidi Mwaga takes me to court. He got 10 votes. I got 300. And the court, and what he's accusing me of is some 22 votes. So the court will say, okay, you are right, you stole your 2 votes, but can it change the situation? This one, now that is objective, but let us look at, this one is going to be subjective. Do you think, even if the court were to order that we go back to the Senate and have the Senate cross-examine the deputy president who was impeached, would that anything change? Definitely not. But nevertheless, that is what you would want to see.
Kidi Odoyo says definitely not. He's very certain there would be no difference, absolutely. But you see, for the Constitution, and of course lawyers, like you say, the law is very clear. Knows no emotions, knows no opinion. It is as straightforward as it would be. Maybe the judgment, as far as the judge's innovations and interpretation is concerned. But even if as you pick from where you left it, Evans Ogada also said that we face a monumental audit if we allow the swearing in of Kindiki to proceed. You see, these are the two orders that we're looking at. One of these things could possibly happen. And according to him, we are facing a monumental audit. A common man should want to understand where he was coming from with this submission. And also, even as you key in your thoughts in as far as, do we have a crisis? Is there anything whatsoever in as far as this hearing is concerned, putting the country in a quagmire? And as far as the position of the deputy president is concerned?
I think for the benefit of the viewer, let us appreciate that the right to fair hearing, as anticipated in Article 40, Article 25, as anticipated in Article 50, as contemplated in the Constitution of Kenya 2010, is non-derogable. We must also appreciate, for the benefit of the viewer, that there was a bit of a rush in making this determination, and because there was almost 24 hours time frame that we should have waited. Again, for the benefit of the viewer, we must appreciate that rationalizations and scapegoating in the political processes are usually the psychological cataracts that stops us from seeing our own sins.
I'm sorry to interject, a bit of a rush, but all these particular bodies or houses, in their arguments, even including the president in his nomination, acted within the period of time given. If it says 14 days, we could do it within the first day, is it?
I'm still speaking about the impeachment.
Okay.
So that when the nation was told that the deputy president impeached had fallen sick, I think that the Senate should have given him up to the following day, so that until it would have been evident that time was running out, then the Senate should have proceeded. But you see, we all know that if wishes were horses,
all right,
beggars would, yes. So then we must also come to this realization that now that we are here, what ordinarily should happen?
Okay.
That takes me to Article 149. Remember that we have not been in a situation where we are dealing with a matter of this magnitude, where we are impeaching a deputy president. Article 149 of the Constitution envisages that when there is certification that there is a vacancy from the Senate, the president then nominates the deputy president designate, then sends that name to the National Assembly for vetting. So to that extent, I disagree respectfully with the view that there should be public participation in appointing of the deputy president designate, Professor Kidi Kindiki. And I think I would call it what Sharad Rao, while writing the Judges and Magistrates Vetting Report in 2013, calls legal disingenuity. It is a legal disingenuity that, in my view, is intended to drag out this political process. Thank you.
Thank you very much. I'll come back to you for your closing remarks. So, gentlemen, I have 3 minutes, 1 minute each, for your closing remarks. Let me start with Wakili Okach. And as far as where we have come from, where we are, what we then expect through to Thursday. Wakili.
Yes, I first of all agree on the part that in terms of public participation, we do not, it cannot apply in respect to the deputy president designate.
Okay.
Where we are in terms of these matters is that we expect that this decision is monumental, extremely monumental, because it can lead to the deputy president designate taking office, and may actually also have a lot of political implications. It is also important because if it doesn't take place, if the court does not or maintains the orders, it then means we must now see the interplay of then the deputy president, whether they will also declare whether those orders meant that the deputy president, Rigathi Gachagua, remains in office. If they do so, there will be a lot of political issues, ramifications, whether he can go to the office, a lot of things. So it's a space to watch.
Thank you very much for that. Let me hear from Odoyo Owidi.
I think currently in the country we are misusing public participation to stop so many things that would ordinarily go well. From the Constitution, there are no proper parameters placed for public participation. No proper parameters. And even if they were to be placed there, I do not think one would say, if it goes this way, then the rights of Parliament to impeach would be denied. The rights of the Senate to impeach would be denied. So I think the real reason why public participation was in the Constitution was to create awareness within the public that this is being done by your elected representatives, appointed officers on your behalf. Do you have anything to say? But I don't think it was meant to deny those officers their powers. In any case, this very Constitution went through the largest form of public participation called a referendum. And it's the one that gave powers to the Senate, powers to Parliament to do all that they did. Thank you.
Thank you very much. Let me also hear the closing remarks of the lawyer and convener Interparties Youth Forum, Kidi Mwaga.
Asante, Anki. I think that one thing that is now very clear, particularly after the formation of the broad-based government, is that for far too long we have looked at different sides of the same coin. That we are here 4 weeks dragged into this circus, and we do not hear any intelligent proposals on how we are going to cure unemployment, on how we are going to avail access to healthcare to our people, on how to prepare our young children for the globally interconnected economy, is proof that it is time for the people of Kenya to develop a viable alternative vision.
Kidi, even as you speak, you're not aware of the 9 million or 9 billion thereabout that is going to be pumped into the hospitals to cure this transition to SHA. Now that you're saying there's no intelligent conversation, I believe that's
as we are speaking, Anki,
yes.
Remember that there is so many Kenyans that are still suffering because they are forced to pay out of pocket. By the time we were doing that transition, that money should have been availed, so that there would have been a seamless transition.
All right.
Until then, because it is still a promise, and again, the vision we are running on at this moment is a vision based on promise. We must now develop a vision that challenges the people of Kenya to work together. And that working together will start from the ballot. It will go into whom do you donate your powers to.
Very interesting. According to Kidi here, even if they say it is by the end of the week, it remains a promise until he actually sees it implemented. Kidi Mwaga, who is a lawyer and convener Interparties Youth Forum, thank you very much for creating time to be here. Odoyo Owidi, a political analyst, for creating time to intentionally speak to Kenyans. Thank you very much. And